My name is Mark O'Brien. I am an estate administration attorney here at Copenbarger. I've been with Copenbarger now. I believe my 3-year anniversary will be, I think, 4 days from now. So I've been here for 3 years. Prior to that, I worked at a firm only about 4 or 5 miles away from Copenbarger for about 7 years. And then for about 5 or 6 years prior to that 7 year stint, I worked in LA County, downtown Los Angeles, the West Side, Century City area, Beverly Hills area, practicing in estate administration, which encompasses trust administrations, probate administrations, conservatorship administrations, guardianships, incapacity administrations, as well as estate planning, tax planning, high net worth planning, business succession planning, and generational wealth transfer planning. So all the areas that we here at Copenbarger practice in, I have some experience one way or another handling that, but today we're really going to be focusing on incapacity. Again, just as a general disclaimer, right? Everything we're talking about today, educational purposes, it does not constitute legal advice. I'm going to be speaking in generalities, or I'll be speaking anecdotally about things I've come across or planning that I've done or issues I've come across or other colleagues have encountered. If you have specific problems, specific issues, or just general questions about your own plan, please reach out, contact us. We'll sit down and have a detailed discussion about your particular matters. And that way we can be informed, you're informed, and we can give you actual legal advice. This is just for general public educational purposes. Again, some background. These are some, you may be familiar with quite a few individuals on here, and there are some new faces as well. The top row is really mainly just our estate planning attorneys. The middle row is really our estate administration attorneys, and that bottom row are our business, tax, advanced planning, and estate litigation attorneys. Like I said, you've probably seen and discussed with one or two or maybe more of these individuals, especially if you've attended any of our in-person seminars. You may have had a chance to meet quite a few of us. And this is just a general a picture taken a year or two ago of not just the attorneys, but also the support staff, the paralegals, the marketing department, billing, accounting, so on. A lot of the people who actually make the firm go around. Okay, in some of our offices, I'm located here at the South Coast Metro office in sunny Orange County, California, but we have offices all throughout the state of California, and some of you may have visited or live closer to some of those other locations. But again, I'm kind of here in the main office in South Coast Metro, Orange County. Okay, let's dive right in. I know that your time is precious, and I'm going to do my best to try to keep this webinar to a minimum. If any of you have attended my webinars in the past, you know that I love to talk and go on tangents, and we'll end up speaking for an hour. So I'm going to try to keep this nice, short, and sweet. This will be a multi-part series. So at a minimum, we will have a part 2. If a part 3 we deem necessary or appropriate, or if it provides some type of benefit or sustenance to all of you who are joining, we will add that part 3. But we'll kind of flesh that out to just know for no matter what, we will be having a part 2. Part 1 today is talking about incapacity. What is it? What is capacity versus incapacity? In what manner are we looking at those two terms? Establishing it in the various ways you can establish it. If you don't have a plan, what that looks like in the different ways, and knowing your documents. And then if you don't have a plan, what that looks like, and trying to avoid conservatorships and those types of court involved matters. So then we're going to talk about some practice pointers, some things you can initiate in your own plan if you're managing your loved one's affairs when they're incapacitated, things to be aware of, some tips and tricks, and then a lot of just the gambit of related items when it deals with when a loved one or family member or friend has lost capacity, is losing capacity, or if you're just generally planning for it. A lot of people focus on estate planning and what happens when someone passes away. And that is wonderful and great. And we are very happy that you're taking being proactive and having the prerogative to do that. But what's also just as, if not more important, is planning for incapacity. Incapacity, in my opinion, is much more difficult, is a much lengthier administration, and there's a lot more risk and exposure involved. And it's, in my opinion, dealing with the probate when someone passes away, yes, expensive and annoying, doesn't it pales in comparison to having to deal with the conservatorship in terms of length, time, expense, frustration, stress, and the corrosion of family relationships that happen because of that. So we're going to talk about a lot today and a lot of things you could do to negate that, be aware of, and things you could sit down and now be armed with information to review your own documents and truly understand, oh, this is the selection I chose. Now I understand the mechanism and I understand what has to take place. Like I said, the first step, get your estate plan done. That's great. Second step, fund your assets into your trust. Now, third is I need to understand these documents in their entirety so that I know when a major life event occurs, what needs to happen next. And if it's not necessarily you taking that action, you know who to contact to take that action or to help assist you with that next part. So these are some of the general topics we're going to be covering today. Part two of the series is really going to dive into, okay, your loved one is, you have the proper documents, you understand them, you understand the mechanism, your loved one has been deemed incapacitated for the numerous purposes that we'll talk about. Okay, what's next? What are the legal requirements? How do I marshal their assets? And I'll briefly talk about those things as well. I'll weave them into this as part of our discussion, but I'll get to a deep dive into that part too. So we're going to be focused on incapacity in two main components. First is medical incapacity, and the second is financial incapacity. So those are the two insular viewpoints that we're going to be focusing on today, and we're going to extrapolate outwards from those two. So most of you probably are aware of these kind of fundamental aspects, right? Your medical for capacity purposes, right, for your medical decisions, it's the ability to make healthcare choices. And generally what that means is the ability to give informed consent. Okay, so a great example of informed consent where someone doesn't have the ability is if they're in a coma, right? They don't have the ability, if someone is in a coma, they don't have the ability to receive the information from the doctors, right? If they have three different options that they can pursue, they're not able to listen and hear and digest those options and then make an informed decision on which path they want to choose. So they need to designate someone to give that informed consent on their behalf. Likewise, financial decision making. Okay, so we're going to be discussing capacity and incapacity for the purposes of making financial decisions. And a lot of that is your ability to manage your finances or your ability to understand your financial portfolio, your ongoing expenses, your needs, your financial needs, where your assets are located, and the disposition of your assets, who you are giving your assets to. Or if you don't truly pay attention to your assets, who's on title to your assets. If you have a joint account with somebody, not realizing you never funded that into your trust, that account is going to go to that joint owner. So knowing and just having the wherewithal of where your assets are, whether they're in the trust, whether they're joint assets, whether you have beneficiaries, a lot of that is a part of the analysis on, okay, do I know the disposition of my assets and where they're going when I ultimately pass? And then a lot of what probably most of you have either heard of or have come into contact with, whether it's yourself or a family member or a friend, is susceptibility to undue influence, manipulation, scams, bad actors, you name it. A lot of times when I sit down with the next in line successor trustee or power of attorney, whoever it is, and they're saying, hey, my sibling or my parent or my aunt or my uncle, whoever it is, has lost their capacity. I have multiple doctors' letters saying that they no longer can manage their affairs and they can no longer make healthcare decisions. How do I protect them? And one of the things that we end up doing, and I'll discuss this a little bit later in part two, is updating title to house. A lot of scam artists nowadays are getting really good at sending official government documents, and they'll send your loved one a letter in the mail, and your loved one will open it up, and it'll look like a government document from either the state of California or from the county recorder. And it'll say, hey, for this fee, we'll pull title on this property and we'll transfer title for you. And then you thinking that this is some type of government document and you not having capacity because of some type of neurological decline or whatever disorder or whatever diagnosis that your loved one is suffering from, or use myself, I'm suffering from in this example, I end up signing it and I end up hiring the scam artist, and then they ultimately send me a deed and I sign and notarize the deed, and I don't realize I just transferred the property out of my trust and to that scam artist, right? And that scam artist now holds title to my home and they can sell it to a third party, or they can do a private sale. And all of a sudden, I don't own my home anymore. So a lot of times during incapacity administration, we will update title. And if you've done your trust, it's a simple process. We follow the trust mechanism and we take the removed, now incapacitated trustee off title, and I put the successor who I'm meeting with. And that way, if that person, my example, I ever get that government looking document that's a scam in the mail, and I sign anything, I don't have the legal authority to transfer title because I'm no longer on title. I was actually removed as trustee and my successor's on. So there's a lot of things that we can do to protect. The same goes for financial assets, digital assets, social media accounts, utilities, credit cards, you name it. There's a lot of protection we can build in. But that's really where a lot of this stems, especially from the financial side, is manipulation. And it could even be manipulation from the family members, right? A lot of you may have come into contact with that. So we're going to talk about how that looks as we dive deeper into this. Okay. So there are two really main distinct ways to determine incapacity: judicial and non-judicial. So we're going to start with the judicial manner because it's good for everyone to have a little bit of background of this. Now, I want every single one of you to avoid this. I never want any of you to have to be dealing with a judicial determination of someone's capacity, but I want everyone to have an understanding. So the law, under California law, let me clear that, everyone is presumed to have capacity. Okay, so it's upon somebody else, the other person, whoever is trying to deem you to lack capacity, they have the burden to prove that you no longer have capacity. It's similar to our criminal system, right? Everyone is innocent until proven guilty. It is the prosecutor, the public defender, or the prosecutor, the district attorney's office. It's their burden to prove that you're guilty. Similarly, it is, if I'm the one who's incapacitated, but I'm refusing to succumb to that, and I don't want to agree to that, or I don't have any documents, and my family members are stuck going to court to do so, right? I'm presumed, it doesn't matter how far gone I am. I could be advanced stage dementia, Alzheimer's, you name it. I'm still presumed to have capacity. And it is the person who is trying to gain control of my financial or medical affairs that has the burden. Okay. So someone can petition the court to deem me incapacitated. Okay. And the judge will usually make the legal determination, and as a part of the documents that are being filed to deem me incapacitated, they will need to, that individual, so I'll just say my wife, for example, has to go get what's called a medical capacity declaration by a physician done. And that physician will say and review my alertness, my memory, my ability to concentrate, my wherewithal, spatial awareness, people memory, all kinds of different areas of a mental assessment to see if I still have capacity for the purposes of my finances or the purposes of my healthcare. And those documents are all submitted to the court. And it's a straightforward process as far as what has to be submitted, but anything and everything can happen, and there's no guarantee of outcome. And this next slide kind of enumerates that. It may take months. It may take years. If someone's trying to deem me incapacitated, I could fight it. And if I fight it, that's most likely going to cause numerous hearings. If other relatives don't like my spouse and they don't want her to be in charge, they may fight her ability to be the one who's in charge. I mean, anyone and everyone can come out of the woodwork. There are certain people that have to be noticed in these petitions, and it can go out potentially to the second degree of relatives, and you may not have even spoke with those second degree in 5 years, 10 years, 15, 20, 30 years. As a part of the process, the court, who is there to protect me and to basically assert my rights, to say that I am capacitated until proven otherwise, they may appoint a public defender, they may appoint a public guardian, they're definitely going to appoint an independent court investigator, they may appoint CAC or PVP, which is court appointed counsel, independent counsel for me. So as you can see, all these now government parties are involved, and numerous family members may be involved. I have an instance a while back where it was a married couple, and the husband, who was losing capacity, had a girlfriend, and he changed his power of attorney to name the girlfriend. And when he lost capacity, and they started to, the people started to need to get access to the financial assets and do things, it was a long drawn out battle between the spouse and the girlfriend. Now, I'm not saying any of you are going to have to deal with that. Hopefully you don't. But all of these other individuals that normally wouldn't have any rights all of a sudden may potentially, and they may need notice, and it becomes a very drawn out, very expensive, very stressful, and very anxiety-inducing event. So we are trying to avoid this at all costs. And if you put together an appropriate estate plan, and I will talk about what that actually means, a comprehensive estate plan, that is part one of avoiding this. But understanding what you've actually selected in those documents is paramount. It's actually even more important because if you don't know the mechanisms within your own documents, you may end up in the court, or you may end up spending time that you don't have, right? Because you may need quick access and quick actions to take place. And all of a sudden you get drawn out and you need lawyers to get involved and the court to get involved. And now what should have been a relatively streamlined, effective, efficient, cost reduced procedure is now drawn out and very expensive and time consuming. Okay, so this is what we're going to try to really focus on for the rest of the webinar, and that's the non-judicial determination of incapacity. And in your estate planning documents, and again, I'll talk about what that actually means. There are numerous different ways that you can declare someone incapacitated. There is a mechanism in your document for all of the documents that you have, your power of attorney, whether it's your financial power of attorney, your medical power of attorney, your advanced healthcare directive, your trust, all of those have mechanisms. And if you need to understand, because even if you did an estate plan with one law firm and they did all the documents, there may be differing mechanisms in each document. And that a lot of times that comes as a surprise to our clients at past firms I've worked at, and there's legal requirements and things that happen. So it's not just as simple as, okay, I'm the named power of attorney. Why can't I just go to the bank and take over my loved one's affairs and financial assets and start using them? Okay, there's a lot more that goes into it. And a lot of times you're going to bring the document to the bank and the bank's going to say, we're not going to honor this. And you're sitting there saying, well, why did this person do this plan? I'm upset. I'm stressed. I need to access these. I need to put my loved one in assisted living. I don't have the money to cover this out of my personal expenses at this time. So understanding all of this will alleviate most of those concerns. It'll reduce or eliminate some of the aspects I just talked about. And then other aspects we can't necessarily alleviate all the way, but you'll be prepared and understand the process, which just makes it help it go smoother. So in our estate planning documents, let's say, when I say that, I'm referring to, the powers of attorney, the advanced healthcare directive, the trust. There are a couple different, generally speaking, main ways to declare someone incapacitated. A lot of you probably heard of a physician determination. Okay. Sometimes in the document, it'll be multiple physician determination. It may say, I am declared incapacitated when two independent physicians have declared so in writing. Okay, something to that effect. It may not be verbatim those words and phrases and sentences, but something to that effect that it says multiple have to declare, or it could just say a single primary, my primary care physician. It could say any physician. It could say independent physician. It could say my neurologist. It could say psychologist. Whatever it is, either it's 1, 2, 3. It'll be very specific in your document. But understanding that is important. I've had times where a loved one has come in to do an incapacity administration and they send me the physician letter ahead of the meeting, which I normally request. And they are, the loved one is thinking, hey, I have this physician letter. It says from Kaiser, my loved one is a Kaiser patient. It says they no longer can handle their finances and they can no longer handle their healthcare decisions. I'm ready to rock and roll. They come meet with me and I say, well, I'm sorry, but we can't do anything for you. And they say, why? I have the physician letter. And I say, well, their power of attorney for finances says you need 2 physician letters. And you can't do anything until you have that second physician letter. So understanding that and reading those sentences and understanding what that means can save a lot of time, a lot of money, a lot of going in circles with not only the law office, but with the financial institutions and the medical providers. Okay, so other than physician determinations, there are something what we call competency determiners. Okay, and what a competency determiner is and I'm going to use myself as for this example and for a lot of the examples. So if I create a power of attorney for finance and I say in there, for the purposes of, I'm sorry, I'm not going to use my part. I'm going to use my trust. Say I've created a revocable living trust and I funded my assets into it. And I put in my trust the mechanism for declaring me incapacitated, right? Which says basically, Mark is no longer able to serve as trustee because he lacks the ability to now manage that fruitfully and appropriately and protectively and safely. Okay. And what I will put in there is, rather than a physician, I will name somebody who makes that determination. I name my spouse as my competency determiner. She is the one who determines whether I have capacity or not solely for the purposes of that document. It doesn't mean carte blanche for everything in the world, but just for the purposes of my trust. And I can name one individual, like it says competency determiner, or I can name a panel. I could say, let's say my spouse has passed away and I have three adult children, all in their 30s and 40s. I could say child A, B, and C together are my competency panel. And I can get very granular. I could say I need unanimous decision. I could say majority decision. I could say if there's a 1-1 tie, another one doesn't vote, I name person D or E to be the tiebreaker. I mean, I can be very, however I want to structure this, I can structure it. I can make it successive. I can put person child A as my competency determiner, and if they cannot act, B, and if B can't act, then C, and if C can't act, then some other relative, right? I get to be really the purveyor of my own domain. I'm the one who gets to pick all of this. Now, of course, if you're using a competency panel, and you'll see this in Copenbarger documents, if you have an estate plan with us, it'll say, I'll use my spouse example again. I name my spouse as my competency determiner, but she has to work in cooperation with my physician. And what that truly means is she should go get a letter from my physician saying I lack my mental capacity and I don't have the ability to manage my financial and medical affairs. And then that doctor issues that letter. And then my wife signs a document that we draft when she comes in to meet with another Copenbarger attorney that says she's accepting her role as a competency determiner and she is now deeming me incapacitated for the purposes of the trust. And then now when she goes out into the world, she has the doctor letter. She has the competency determination document that she's been drafted by a law office and that she's signed. She has a new certificate of trust showing that she's the trustee. She goes to the banks. She removes me from title. They work with her seamlessly, easily, and a lot of the process is done for a lot lower and reduced price than if we have to have multiple meetings with the lawyers, if you have to go back to the doctors numerous times, right? That's just all time out of our busy schedules. We all have, a lot of the times, if you're acting on behalf of a loved one, you have your own family, you have your own job, your own worries, and everything that's going on in your own life. So to add all of this on top of it can get very stressful. So understanding all of this is very important. And at the very bottom, court determination. So a lot of times in these documents, we'll put as a catch-all, hey, you can always go to the court to determine someone as incapacitated. And that's really just a safety net for if, some reason I name all three of my adult children and me and my spouse and all three adult children are on the same airplane and everyone goes down and I'm the only one who survives, but I'm in a coma, right? At that instance, at least there is a mechanism to appoint somebody else or at least for another family distant relative to go into court to determine me incapacitated, giving that kind of just like a safety net so that there's always a way to handle this. But again, we want to avoid the court completely. But again, key takeaway is understanding which one is in your documents and do your documents differ? What does your medical power of attorney, say versus your financial power of attorney? And what does your financial power of attorney say in regards to incapacity versus your trust? Okay, so understanding that those are different documents, they cover different things, and they may have different mechanisms. And we're going to go through in detail what that means. At the bottom of this, this is highly customizable, and in exclamation mark, know what your documents say. Knowing that will help you would understand your own position, but it's also, if you're married or if you're really close with your other family members and someone's named you, have a discussion with them. Sit down and say, hey, I know you've named me as your power of attorney. Can we talk about, you don't have, if you don't feel comfortable showing me the document in its entirety at this time, that's okay. But can we at least sit down and can you go through your document and tell me what the mechanism is and what it looks like and what I may have to do or what information I need to go talk to the lawyer that will expedite and make this process smoother and easier for me? Because all of this planning a lot of times is not to make my life necessarily easier, it's to make my loved ones' lives easier, to help them in a very difficult time. So rather, if I've lost capacity, I want them to be able to spend time with me and grieve, the sorrow and the loss of me being able to really understand what I'm doing and who they are anymore, and spend less time having to worry about dealing with lawyers and CPAs and banks and medical institutions. You can't avoid that. That's all that's going to happen. But to minimize it and make it easier just allows you to be more present. Okay. So understanding capacity, the stages, right? Gradual versus sudden decline. Some of these are pretty obvious, and a lot of you will know these talking points. These crises may happen suddenly. Sometimes it's not a slow neurological degenerative decline from, very minor dementia to advanced. It could be that an accident has occurred. It could be that someone reacts to the neurological disorder in a unique or more rare adverse reaction, and it speeds up much faster than the normal timeline. Or on the other side, the decline may be gradual, and the changes may develop very slowly, and it's only upon looking 2020 over the past 3 years that you actually see the decline. And that's a problem that a lot of times clients will come to me that I cannot solve. Unfortunately, any attorney that you talk to, or any advisor that you talk to that says they have the answer to this, they don't. That's not true, because differentiating standard aging versus legal incapacity is quite difficult. As we get into our 70s, 80s, 90s, and even 100s, right? There's a standard aging process. Our memory starts to go. We're not as quick. We're not as sharp. We don't recognize things as much. It takes us a little bit longer to understand and grasp concepts. Even concepts that we already understood. It may take some pattern and reiteration to really hammer it in and remember. And that's just part of the standard aging process, and not necessarily legal incapacity. So understanding those two will help out quite a bit, because there are a lot of times when clients will come in and say, hey, my parent's losing capacity. What can I do? And sometimes the conversation is, hey, I don't think what you're describing to me rises to the level of incapacity. To me, what that sounds like is just a standard aging process. And I've dealt with contested conservatorships where family member goes and runs and files a conservatorship for their family member and says they don't have capacity because they witnessed this one sign, or they were susceptible to this one scam. And the court may come back and say, hey, look, that's just part of the aging process. We don't believe this has rose to the level of incapacity. So understanding that, being aware of it, talking with your family member. I have in some instances where you're in that gray area, and not everyone will have the situation or circumstance to do this, but when it is possible, it's fantastic, is when the person is able to self-reflect. When I'm able to look in the mirror, I'm 78, I'm 82, I generally have my wits about me. I would say I still have capacity for both finance and medical, but I understand that I'm aging. I understand that I'm declining, and I understand that I've made a mistake here or there, that although they were minor and had no ramifications, that may extrapolate and get worse as time goes on. And I have done proper planning. And I meet with my son, who's now 50, and we come together to the estate planning attorney or the state administration attorney. And I sit down with that attorney and say, hey, here's what's going on. What can we do? And the attorney can say at that time, well, you have an option. You can resign. You can voluntarily step down and say, hey, I want my child, who's the named successor in my example, to step in and start managing my affairs. Right? If I trust that person, I've named them as my agent, and they're being involved, and we have great transparency and communication, and everything's on the up and up, that may be a great idea, because all I have to do is just sign a resignation. No one's determining any type of capacity, and I get to retain the autonomy. I get to say, hey, world, I'm choosing to step down. And as we know, sometimes as we get older, we like to keep that control, and telling ourselves that we're losing capacity is a very hard conversation to reflect on and to have with ourselves. But if we're able to do that, sometimes that saves a ton of time, a ton of money, and it actually helps the transition a little bit easier. And ultimately, that's what all of this is about, whether it's incapacity, death, life planning, business succession planning, estate planning. It's all about transition. It's transition into the next generation, or whoever you've named as your successors, your heirs, your beneficiaries, transferring it to them so that they can manage and help you with that process. Again, whether it's incapacity or you've passed away, whatever it is, right? So there are sometimes when that voluntary resignation is best, or if you still have the capacity Appointing a co-trustee or appointing a co-agent, having someone serve with you so that you can start to off burden some of the things that you no longer want to handle, some of the things that that person may be willing to handle, but that's a conversation you need to have with whoever you're wanting to either name as a co-agent or step down completely so that they can step in your place. You have to have the communication. They need to be involved because we can't just saddle them with all of your financial and medical affairs. They need to be willing to accept that, and they need to be prompted and provided with all of the information so that they can feel comfortable, and so that their entire life doesn't turn upside down by having them take over everything in your life. So understanding that is really paramount, and great moving forward. So understanding capacity when crisis strikes. Some of these are straightforward, and some of you may have already encountered this when you've handled a loved one's affairs. Accounts may be restricted. Banks want to freeze that account as quickly as possible. They are reducing their headcount for their internal legal departments on a daily basis. They're cutting those costs, and they are always risk assessing. They want to reduce their risk and liability. They don't even really care what the law says. They don't really even care if you have a valid legal document. They want to do what's right to protect them. The hospital, more and more days, want to do what's right to protect them. We live in a litigious society. We also live in a society where financial institutions and medical institutions, are getting so big, and there's so many of them that there's just way more cases of financial and medical elder abuse, and they're trying to protect themselves, and they are following internal policy as opposed to California legal policy, or if you're out of California, whatever state you're in or whatever federal law implicates it. So understanding that you're going to be at a just you're going to have tension immediately from a lot of these institutions. So just prepare for a not smooth process because they're trying to protect themselves, not follow your loved one's wishes. Okay. Families face uncertainty. Immediate action is often required. A great example I always use, I have quite a few clients who come in and say, hey, I'm trying to put my parent in assisted living, or I'm trying to put my loved one in assisted living, and I can't access their funds. I have the first payment. I'm going to come out of pocket to cover that. It's $10,000. I can't keep making $10,000 payments every month. I need to access their funds to do this, and I need immediate action. I'm putting them in, next week, and I'm flying down. I live in Delaware, and I'm flying to California. They're going to be putting assisted living here. I need to get all this done, and a lot of times that causes a lot of stress, and there's a lot of actions that have to happen. And knowing your documents, knowing what triggers the mechanisms, what you need in advance, and understanding what, once you have satisfied all those things, what are the legal requirements? And that's why I'm going to stress, please everyone attend part 2, because I'm basically going to talk about, hey, excuse me, you're meeting with me. I'm going to go through like a consultation, essentially. You're meeting with me, and I'm telling you all the legal requirements that we have to do: legal notices, updating title, marshaling the assets, dealing with creditors. So understanding a lot of that will help save time, help you put yourself and your loved one in a better financial position, put in a better healthcare position. You get to determine a better facility because you have better access to funds, better care, understanding what type of insurance, whether they have Medi-Cal versus Medicare versus Medicaid versus if they have a long-term care policy, right? All of that comes into fruition, and understanding that in advance, huge, absolutely imperative. So like I said, some of these things: increased emotional stress, we've covered; decision-making challenges, need to coordinate; unclear authority concerns, and questions must be resolved. So establishing incapacity, who can act and when. And now we're going to start talking about, some of the different documents themselves, who is named, when they can act, and what that mechanism actually looks like. If your loved one or you has an estate plan, sit down, review the documents. Look at your advanced healthcare directive. Look at your medical power of attorney. Look at your financial power of attorney. Look at your trust. Usually, they're pretty straightforward as far as a table of contents, or getting to the large header that says when this document is effective, or it'll say something to the effect of when, how to declare, the principal or the trustee or the settlor, one of those terms, how to declare them incapacitated. And those are always great paragraphs to start with. But again, review your documents. And if you review them and it's not clear, schedule a meeting with your estate planning attorney or estate administration attorney to sit down and go through those documents with you so you understand. Okay. Who is or are named as the agents? That's always number one. Who did you name when you first did these documents? I always tell my clients, and you'll see it on a later slide, you should be reviewing these documents every 3 to 4 years. Who you named may still be who you want to serve, but circumstances and life events may have made it so that they can no longer serve. And here's some of the analysis that you need to go through. You may have named person A to serve as your power of attorney, your spouse, and you named your eldest adult child as your backup to serve as power of attorney in the case your spouse cannot serve. But you need to look at, okay, it's now 15 years later. I need to look at the location, the bandwidth, and the ability. Well, my eldest son has relocated and now lives in London. Okay, so from a location perspective, might be an issue. Further, naming international individuals may not comport with California law. For a trust, California law, if you name an international trustee, there are all types of foreign trust rules that you trigger, and that person needs to have a co-trustee that's based in the US, right? So understanding the location of your agent, the bandwidth. What if you've named your spouse as your power of attorney and then your eldest adult child, your spouse passes away and you're looking at your eldest adult child, but what if he or she does not have the bandwidth to serve? What if, I'll use my parents who actually I think should be attending this. I told them to, and they confirmed. So this is a perfect example for them to I get to use them as an example here. It could be that they've named me. I'm in California, they're in California, but what if I don't have the bandwidth? What if I have too much going on in my life where my own family, my job, my financial stress, my own medical issues are making it so that I cannot appropriately care for them, right? So understanding that, using that analysis to say, okay, I need to stay in communication with my son. I need to be understanding of and aware of his bandwidth in that instance, my bandwidth in that case, understand if I'm the appropriate person. And I also need to be talking with them to say, and touching base, say, I don't think I can handle this. Maybe you should update your documents to name me as a backup. And then in the future, if I have a different, my life circumstances change and I now have their bandwidth and my parents still want me to be the first in line to serve as their power of attorney, great. They can update their documents and reorder that. But just kind of touching base and having the conversation with these people and understanding their location, their bandwidth, and their ability, right? It could be that I was the appropriate person to serve as a successor trustee or a successor power of attorney for financial decisions for my parents. But what if something in my life, they did these documents 15 years ago, and 7 years in, something happened to me, and I became an alcoholic, and I kind of went out the deep end. And even though I'm an attorney, and even though I work in this area, and I have a financial background, I have tax background, and I'm on paper probably the best person to serve, I am no longer the best person because I have had issues in my own life that have caused me to lack the ability to actually care. So reviewing the documents, knowing who you've named, and then actually doing a deep dive into, are these people still appropriate to serve on my behalf? And there's some other factors you can look at, but really these are the kind of the main ones to be thinking about when you're looking at who you've named as your agents. And again, this is for any one of your documents. If your loved one does not have an estate plan, okay, if you don't have a trust, you don't have powers of attorney, advance healthcare directives, you need to do that yesterday. Okay, so if you have not done that, get that done immediately. If you do not want to pay for one, there are a whole, California provides what's called a statutory power of attorney for finances and a statutory power of attorney for medical decisions. Please go download that and do that. They are terrible documents. They are wholly inadequate, but it is something. You do not want to be caught where you or a loved one no longer has capacity. And when they lose capacity, they also lose their ability to execute contracts and estate plan documents. So if they've lost that capacity and now, my brother's lost his capacity and I'm scrambling because I need to get him in assisted living or whatever the memory care or skilled nursing or this facility or this hospital, and I'm running around and I don't have the authority, right? The medical institution is going to say, what authority do you have to make the decisions? I don't have any paperwork. And then they're going to say, well, you can't go get this paperwork because your brother doesn't have the ability to understand it and sign. So they're going to ask you for your court documents. And what they're really referring to in California is a conservatorship. So in California, for anyone 18 years and above, We call it a conservatorship. In other states, there are other states who call guardianship anything, from a 1-year-old all the way up to a 99-year-old. But here in California, it's a conservatorship for someone who cannot care for their own affairs, 18 years and up. I have to go file that. So, but here's the problem. Who can file, right? I, in my example, said I'm trying to file for my brother, but does someone else have priority? Yes, his spouse. Under California law, spouse has priority rights to file this. So if I file this, and his spouse does not like me, right? We are now in a contested conservatorship. So now we're fighting over who has the ability to make the decisions. And by the way, no one's been appointed. So my brother is still languishing and no one has the ability to make the decisions. And the hospital, back in the day, the hospital would have been more likely to say, hey, spouse, we need you to make a decision. Nowadays, they're saying, hey, by law, spouse, you don't have any rights to make this decision. Hey, adult children, you don't have any rights to do this. We need the court documents because we don't want someone to sue us later. And that's the way they're going to take. That's the angle they're going to take. And if they don't take that angle, I would be very surprised. So I do have clients that come in and say, hey, the medical facility just took the documents and took what I said. And I always advise them, well, legally, that's not correct. What the hospital did was they broke the law. Okay, but maybe you go with it because they were willing to accept it and they're willing to expose themselves, but that's not how it normally works. So again, identifying who can file that and then what type of conservatorship. So there are two types of main conservatorships, a person conservatorship and an estate conservatorship. And they're self-explanatory. A conservatorship of the person is for medical, social, health decisions. A conservatorship of the state is for financial decisions. You could file those at the same time on the same petition, or you could file them separately. Sometimes you don't need both. And then there's a separate category for what are called limited conservatorships, but those are for minor children who were born with developmental disabilities and are now turning of age. But I've done prior webinars on that one, so I'll direct you to a separate conversation for those types of conservatorships. But again, we want to avoid this conservatorship at all costs. I have a conservatorship webinar if you want to look at that in greater detail to understand it, but it is very expensive, very time consuming. A bunch of different parties are involved. The government's involved. The court's trying to stop anybody from getting those powers because they're there to protect the individual. And it's all done over months or years span. Meanwhile, your loved ones not being cared for. Okay, so types of powers of attorney. So you've signed your power of attorney. There are a couple different types, as you can see on the screen. There is a general power of attorney, which is your broad financial legal authority, a durable power of attorney, which remains effective after incapacity. If you've done a power of attorney with us, when you review the documents, it says effective upon execution. So when I signed my power of attorney, and it says effective upon execution, that means, and I name my spouse, she's actually my power of attorney when I signed that on January 1st, 2025. Okay. So understand, and it'll say, even when I become incapacitated, it remains effective. So that is a very useful tool because technically the second I become incapacitated, my spouse automatically already has the ability to use that power of attorney. But again, you have to know your documents. Your document could be a springing power of attorney, which is usually becomes effective upon a specified event. Usually it's tied to incapacity. So it'll say something to the effect of this power of attorney is not effective until I've been declared incapacitated. And then go down a paragraph or a section and it'll say, this is how you declare me incapacitated for the purposes of this power of attorney. It'll say physician letter or two physicians or a competency panel, whatever it is, or a court determination, whatever the selected method I've chosen, right? That power of attorney won't be effective. So understanding whether you have a durable or a springing is key. And then telling your agent that is also key so that they understand that they can't, if it's a springing, my spouse can't just take that document and go to the bank. She has to use the mechanism within that document to declare me incapacitated before she uses that. So understanding that is very important. And then last but not least, we have limited or special power of attorneys. These are usually restricted to specific tasks or specific duration. I am leaving the state of California. I'm traveling to Hong Kong for a month, and I want my brother to have the ability to manage my financial affairs. So I do a limited power of attorney for that month period that allows him to pay my property taxes, pay my utilities, pay my credit card, do whatever I need to do because I'm out of touch and won't be able to manage that. Financial powers of attorney. What powers are actually given in that power of attorney depend on the document. Okay. When it is effective depends on the document. This is highly customizable. You, me, as the principal, the person executing this power of attorney, gets to choose what powers are in there. I could give carte blanche. All powers and any powers that I could conceivably have, I'm giving to my agent. I could have most powers, but eliminate some of those powers. I could say, hey, power of attorney, you have all normal rights that I would normally have, but you do not have any authority to manage my business. I have a law practice and only the other partners have that ability. So I don't give you that, right? I've customized to not give you that ability. Or I can make it very limited and say, hey, I'm only giving you, ABC powers, the rest you do not have. Okay, so it's highly customizable, and knowing what yours says is important. What's as just as of importance is understanding what does your financial power of attorney actually cover. It covers anything in my individual name. So my credit cards that are in my name, my social security that's in my name, my retirement that's in my name, my pension that's in my name, my utilities that's in my name, right? All of kind of my day-to-day stuff that's in my name that I cannot and will never transfer into my trust. That's what this power of attorney covers. Okay, and you can see some of those examples are on here. So understanding that your power of attorney for finance covers basically everything outside of the trust for finances. Okay. Understanding that's also very important. I've had people that have come to me, we've doing an incapacity administration, and they take their power of attorney to I'll use my brother example. I take his power of attorney to his bank and I say, I'm the power of attorney. It says effective immediately. He has incapacity. Here's the physician letter. I'm ready to rock and roll. And the bank goes, nope, sorry, you can't touch any of this. And then my attorney say, hey, this didn't work. Why'd you give me a faulty document? And the attorney goes, actually, well, what's the account title? And I go, well, it's under the trust. I go, well, you just used the power of attorney to try to govern trust assets. And that power of attorney does not cover those trust assets. You need to give the appropriate trust documents for a trust asset. You need to give the appropriate power of attorney for the individual assets. So understanding that the interplay between those is really helpful, because those two documents together, the financial power of attorney and the trust, are supposed to work together over someone's complete financial estate. So again, this kind of touches on what I briefly discussed on the last slide. What does a financial power of attorney not cover? It does not cover trust assets. And it shouldn't. If you've properly funded your house into the trust, I, as the financial power of attorney, can't go then sell that house. No, only the successor trustee of my trust can step up once they've done appropriate incapacity administration, they've updated title, then they can sell their house, then they can refinance, then they can get the reverse mortgage, then they can rent it out to generate more income to pay for the assisted living. Okay. And also, the financial power of attorney does not cover healthcare decisions. Again, customizable provisions. So if I put something in my power of attorney that says my spouse cannot control my law practice, even though it may be a financial decision, she doesn't have the authority. I've restricted her ability to do that because she's not a practicing attorney. By law, she cannot do that. Also of important note is documents will face scrutiny for things that don't qualify them as ineffective or no longer appropriate. So you could have an effective power of attorney. You signed it. It's done appropriately. You understand the mechanism. Your agent understands the mechanism. And I take my brother's power of attorney and I bring it to his bank, and it's for an individual account in his name. I have no one's fighting me. Everyone's on board. The bank's not fighting me. And I give it to the legal department and they go, hey, we're not going to accept this power of attorney. And I go, why? What's wrong with it? And they said, well, your brother executed this in 2005. It's 2026. It's been 21 years. This document's stale. We are going to assume, even though by law it's a completely legally appropriate and effective power of attorney, we, the bank, are going to assume that he has revoked it and executed a new one for our own liability purposes. And I go, why? Under what rationale do you have to do that? And they don't have a legal rationale, but you're still going to get blocked because they're the one who has to process this. So understanding that if you have very outdated documents, even if you've done the analysis we've talked about, sitting down with an attorney and even having an updated one, even if it's all the same provisions with a new date or a more current date can stop a lot. If documents are revoked or it's unclear, you're going to get a lot of pushback. Amended handwritten changes, anytime clients handwrite on these documents, realize that you are affecting its validity, and you are raising the level of scrutiny that they're going to be looking at. Please do not put any handwritten changes on any of your estate planning documents. If you want to make changes, contact your estate planning attorney and have them do follow the appropriate legal mechanism and channels to do it so that you can reduce scrutiny. Healthcare powers of attorney, same concept. What powers depend on the document, when it's effective depends on the document. And again, highly customizable. And what does a healthcare power of attorney cover? My social, medical, healthcare decisions. Okay. I'm going to go quickly to this slide because I want to explain a key aspect of our healthcare power of attorney that people do not understand, and they do not understand the difference. So I'm going to skip to kind of the third item here: advanced healthcare directive versus a healthcare power of attorney. You will hear people talk about these two things interchangeably, but they are not the same thing. A healthcare power of attorney, I name as the principal, name an agent, and I prescribe, all of these powers that they can make on my behalf. An advanced healthcare directive is a directive. I put some instructions on that directive and I say to the person I've named, you do these things. It doesn't give them the ability, that advanced healthcare directive does not give the ability to make discretionary healthcare decisions. Okay, so if I am in a coma and they're talking to my advanced healthcare directive agent, and the hospital has accepted the advanced healthcare directive, and the advanced healthcare directive, all it says is, hey, I want to be cremated. Hey, do not resuscitate. And this is what I want my service to have, and where my memorial is, and who to contact, and that's it. That person doesn't have any power to make medical decisions on my behalf. They can just do those things and follow those instructions. So if you've done a medical power of attorney with us, we combine it. So we do a dual advanced healthcare directive power of attorney. But if you have done your own advanced healthcare directive, or you did it at a prior law firm, to look at it and make sure that it is a joint document and that it gives your agent medical decision-making powers. If it does not, then you need to update that document to make sure it also includes medical power of attorney language. So there's a very key distinctions. A lot of you are probably familiar with HIPAA and CMIA. So HIPAA is the federal law to disclose or protect our confidential healthcare information. CMIA is California's state version of that. It has even more protections built in. These healthcare power of attorneys do not cover financial decisions. I've had people bring a financial power of attorney to me and say, hey, I brought this to the bank. Why can't I do it? It says power of attorney on it. And I say, well, this is for healthcare decisions. This doesn't govern that. You need your loved one should have also signed a financial power of attorney. And again, the documents are going to face the same type of scrutiny: stale, revoked, amended, any handwritten changes. So a trustee of a trust, same thing as the past two. What powers depend on the document? When effective depends on the document. Very highly customizable. But what is of the most importance when you're dealing with incapacity is that the trust only covers trust assets. So if again, in my example, I bring the power of attorney to my brother's bank and it's a trust account, they're going to say, hey, you brought us a financial power of attorney, but this is a trust account. We need to see the appropriate trust documents. And knowing what's in that trust, knowing what the mechanism for declaring him incapacitated is, and who has that ability, and what that looks like, is extremely important. And then once that's been done, meeting with the attorney, understanding, okay, what documents do I need to bring to the bank so that they will let me take over that trust account, is even more important. Because let's say I just bring the trust to the bank's going to say, well, this trust says your brother is the trustee of the trust until he's declared incapacitated. And I say, well, he's incapacitated. And the bank's going to come back and say, well, no, there's a paragraph that says you have to do this to declare him incapacitated. Right? So you have to follow that mechanism and do the appropriate documentation, which you should meet with an attorney to have that documentation done. Okay. So just understanding what covers what, how to declare that incapacity for that document versus that document, very, very important. Okay. So we kind of talked about that. The trust does not cover assets and debts outside the trust. So my brother's credit card is in his name. I can't provide the trust of the credit card company to take over that. I have to provide the financial power of attorney. Okay? And of course, the trust does not cover any healthcare decisions. the documents will face scrutiny for the same thing: revoked, amended, handwritten changes, missing pages. Two biggest things: handwritten changes, missing pages. So those are the two probably prevalent items that the banks are looking at. Hey, why is page 15 and 16 missing? Right, that's not a complete trust. They're going to, even if it's like has the 15 and 16 are completely irrelevant pages. They have nothing to do with incapacity or my trustee powers or who the successor trustees are. They may deem that this trust is no longer legally valid because it is incomplete. Or if there's handwritten changes, people love to just sign and make changes on their trust. And it's like, we have to do an analysis now to whether that was a valid legal amendment. And two, can we even prove it was you? Three, were you subject to undue influence when you were making these changes? Where did you make these changes? Were there any witnesses? What type of changes you are? So understanding when an incapacity comes up and you have all these handwritten changes, it's just going to make life for your loved one much harder, much more expensive because much more attorney involvement. You may even need court involvement to reform or prepare the documents. That just becomes a nightmare. So making sure that you're not handwriting any changes and making sure that you're not taking pages out and replacing them or doing anything to elicit advanced or increased scrutiny. So lastly here, kind of avoiding delays and the court, right? So preparing before a crisis occurs. Prepare, this is kind of the whole gist, the whole gist of this webinar. Prepare before incapacity occurs. Okay, so that means putting the plan, getting a plan in place, having a comprehensive estate plan, reviewing it, understanding what it means, every couple of years reviewing it, understanding what it means, who you've named, what the mechanisms are, talking with those agents, talking with the successors. That just helps create clarity for everybody. If everybody is understanding and aware of what this is going to look like and how it's going to look, it just makes it much more smooth of a process, which means anytime it's smoother, less attorney's fees. Also, probably more important than anything is it saves family relationships. I can't tell you how often trust administrations and probate administrations, anytime money gets involved, drive families apart. But incapacity administrations also drive families apart, probably even more, because incapacity administrations, if my brother's 60 years old and he loses capacity, he could live for the 20, 30, 40 years. I may be doing this incapacity administration for a very long time. And that period of time, a lot of different things can happen between our own lives and our family's lives and other interested parties. And it just, the longer it goes, the more chance for strain in relationships. So understanding that can help minimize that. It can't negate it. Sometimes we have people that are estranged or we have very difficult family members and we can't avoid it. And sometimes it's just not avoidable, but having the discussion so that we can try to clear that up helps a lot. Support continuity of decisions. Again, understanding your documents really help protect everyone involved. More importantly, the person and the people that you've named to act as your successors. So again, a lot of this will just reduce financial delays. The decision makers are identified clearly, proper documentation is maintained, you've already addressed potential obstacles, and you've improved crisis readiness. Reducing healthcare delays, same thing. Decision makers are identified, the documents are available, the mechanism for what powers or that does this person have, what powers don't they have, when does this document become effective, is this document still legally viable, is it too old, are my agents who I've named the right people? All of this improves the decision continuity. Create a coordinated care plan. That usually means talking with all of the people on that slide, the lawyer, the physician or physicians, their care facility, the family, the therapist, the friends, the caregivers, or other advisors. Having everyone on board makes this process so much easier. If my parents have talked to their investment advisor where they have a large investment account at, and I've been clued in and we've talking and we've coming up with a plan, and I know exactly what facility that my parents want to go in, or if they don't want to be in a facility, they want in-home care, developing the financial plan to support that plan that they are seeking, or to talk to them about, hey, this is not a viable plan based on your current assets. So we need to start discussing, okay, do we need a reverse mortgage? Do we need to sell? Do we need to rent out the house? Do we need what else? Whatever we need to do, we're creating that care plan in advance so that I'm not scrambling when that time comes. Okay. And avoiding court involvement, and I kind of touched on this throughout. Create the comprehensive estate plan, fund it, review it every 3 to 4 years. and talking to my parents on this one because they did their trust a long time ago. They need to review it. It's been way past 3 to 4 years. But any of these major life events, and just every 3 or 4 years in general, sometimes it's there's California law updates, sometimes there's federal law updates that affect your documents. Sometimes there are nuances that are not publicly broadcasted. For all, a great example in our state planning department has done a lot of webinars on this is that Kaiser requires, if you're a Kaiser patient or you have Kaiser plan for your healthcare, you need to know that they require specific language on their advanced healthcare directives and their medical powers of attorney. So understanding that is a very small nuance that doesn't have anything to do with a major life event in your own particular circumstances. It's just something Kaiser initiated. So updating your document to comport with that helps you when my brother loses his capacity and I take his healthcare power of attorney to Kaiser to start making decisions. I've already built in my documents already up to their standards, and that helps that process go along a lot faster. And that's just being proactive. That's touching base with your documents every 3 to 4 years. And sometimes you review your documents with the attorney every 3 to 4 years, and not a single change needs to be made. And that's, best case scenario. But if there is a change, it's also best case scenario because we're catching it in advance, which just means lower fees, less stress, and everyone's protected. So these are just kind of general talking points, when to call us, establish, or you need to establish these documents, if you need to update them, if you need to discuss whether your plan reflects your now current wishes, to navigate uncertainty when capacity becomes a concern, understanding who can act and when they can act and how they can act, developing a strategy that's tailored to your family's needs. Conclusion. So I want to skip to this part because this is what we're going to be talking about part 2. So you've reviewed your documents, your loved one has lost their capacity, you know the mechanism, you're named, or your family member who you're going to be helping in this process is named, and now you're meeting with me. You're meeting with a state administration attorney saying, okay, I have the physician letter, I'm the named competency determiner. How do I do that? Power attorney was effective immediately. I'm the named. How do I establish that this power attorney is valid? And I go to the bank and I update title. It's basically going to be a run through of the consultation you're going to have with me. It will prepare you for that conversation. You can come with way more informed questions, which will just reduce the amount of attorney assistance you need. There are some things which we'll all go through that the attorney has to be involved in and you want the attorney involved in, but there can be some things that we can offload to you that'll reduce fees, it'll reduce costs, and then also just understanding what that consultation is going to look like will just help you after that consultation move forward quicker, more effectively, and understand your ongoing fiduciary duties, where you're exposed, where the liability is, and everything you can do to minimize that. And that will include all the legal requirements, the legal notices, actually how to go marshal and take control of assets and finances, how to deal with medical decision-making, record keeping and accounting requirements that are required under California trust law, or just standard California law or federal law, and then understanding your ongoing fiduciary duties to your loved one who you are now in charge of, essentially. And then also, well, briefly touch on special needs planning, supplemental needs planning, disability needs and/or planning, long-term care planning, and then a little touch on Medi-Cal and Medicaid planning. We have separate webinars for each one of those, but I will briefly touch on those so you can, just as a general reminder of those items and when they apply or do not apply. Lastly, some, again, basic information about our firm. If you're a current client or a newer client or a potential client, just some information on when we opened, how many clients we have, the amount of attorneys, our experience, have a ton of advanced degrees, a lot of combined legal experience, numerous certified specialists, numerous people with advanced degrees. And lastly, reach out, contact us, call anytime, visit our website, email us if you have questions. Please send your questions to our marketing department. You can respond to the confirmation email for this Zoom webinar, email us, schedule a consultation, even if it's just to review your documents to make sure they're current and you don't need actually any work. That's perfectly fine. We'd much rather you come in so that we can ensure that your plan is still current. Leave a digital evaluation about the webinar. Any positive feedback, I always welcome that. Any negative feedback, please, any constructive criticism, I take that very seriously because it helps me design these webinars to be more fruitful for you and just the public in general. This is recorded. We will send out a recording that will be available if you want to rewatch this again for specific parts that you believed are more important or more pressing to you. But again, please fill out the digital evaluation. Let us know how we did, how I did, what you liked, what you didn't like, and also if there are topics that you want to see related to this discussed in greater detail, put that in there. And if there's enough material or if there's enough desire from our clients, we'll definitely explore that. Otherwise, thank you very much for joining me today. It was a pleasure speaking with all of you and providing you with this information. I hope it was beneficial. And like I said, fill it out, reach out to us. And we hope to hear from you soon. And hopefully you join us for part 2, because that's going to be probably even more beneficial, because it's literally going to be a consultation for the incapacity and what I'm going to discuss, what it's going to look like. You're going to know what legalities there are, what notices, what you actually have to do to go take control of these assets. It'll be very beneficial for you and your family. Okay. Like I said, very nice meeting with you again. Everyone have a blessed rest of your day. Take care, and God bless.